Previously, on Murdaugh Mafia Rise and Fall, we covered some moments leading up to the Colleton Whiskey Conspiracy case and the first few days of the trial. We heard from Edith Freeman, the meticulous bookkeeper, who testified about payoffs and a stolen $13,000 that was taken after her husband was shot by federal agents. We heard from a federal agent who hid in the trunk of a car to record Sheriff Thompson speaking to bootleggers. We heard the testimony of several bootleggers who spoke of stills being set up under the direction of members of law enforcement and court officials. We heard the amounts they paid for protection. In this episode, we're going to move through the rest of the testimony in the trial. I'm Cassidy O'Connell, and this is Murdaugh Mafia Rise and Fall, Bootlegging Buster Part 3, The Original Web Weaver. Welcome. The 2-day plea. As the days passed on, less details of the court's activities were being printed in the daily papers. Sometimes the story didn't even make the front page. We're picking up on day 4, where there's yet another change of plea to guilty. This plea was different than the others. It was made by Jimmy V. Richardson. He had attempted to make it the day before, approaching the judge after the jury had been dismissed. Judge Hoffman began, "I've been told that you wish to change your plea from the original one of not guilty to one of guilty. I want you to realize that this court does not invite anyone to plead guilty. That, of course, is your prerogative. So far, your name has not been mentioned at the evidence presented. On that basis, you're a free man. Of course, the government will probably have evidence which it intends to present against you. Again, the court does not invite a plea of guilty." With that, Hoffman persuaded Richardson to think about the matter overnight. Richardson returned in the morning, still wishing to change his plea to guilty. He also told the judge he wanted to discharge his counsel, Edward K. Pritchard. The judge warned him that he could not let a defendant plead guilty without benefit of counsel, because that could lead to a mistrial later. He explained the defendant's rights, and Richardson once again withdrew his guilty plea. He came back that afternoon, however, and this time the court accepted his guilty plea. He pleaded guilty on the conspiracy charge and one charge of operating a still. 5 other still operating charges were dropped. Also of note on that day, one defendant was removed from the list of defendants. Mrs. Ulmer's husband remains a defendant, but the evidence against Mrs. Ulmer simply amounted to her driving up and stopping on a roadway near a still that had just been raided. Based on that, District Attorney Belzer had filed a motion to dismiss charges against her the night before. When granting this motion, Judge Hoffman remarked, "I expected your motion. If that's all the evidence you have against her, it's just as well that you made it." Mr. Ulmer remains on the defendant's list, as his charges are much more serious with conspiracy and operating a still. We'll now move on to testimony. It began with Highway Patrolman L.M. Kaiser. While doing his job as a patrolman, Kaiser had seized an automobile that had 26 cases of bootlegged whiskey in it. In his testimony, he tells of Sheriff Thompson offering him money to release that automobile. The court then moved on to Glenn Cartherin, an ATTD agent. He corroborated earlier testimony about the setting of recording machine traps. He told the court that he was one of the agents that took part in setting the machines up, and also stood watch, waiting to record Sheriff Thompson. He told of a series of investigative trips to Colleton County throughout the year 1955, testifying that a number of recording machines were used to take down conversations between informers and Thompson and a bootlegger named Anderson McFadden. He identified the voice of Deputy Sheriff Lucas Hyatt speaking to bootlegger McFadden, saying, "You better watch out. They're walking in with walkie-talkie radios now." Hyatt's counsel objected, asking how he could identify Hyatt's voice after hearing it only once, to which Carthen replied, "He's got one of those loud voices, that once you hear it, you know when you hear it again." Testimony moved on quickly to Robert B. Lane, also an ATTD agent. He corroborated these recordings as well, but also produced records showing deliveries of large quantities of sugar and fruit jars to defendants Ulmer and Hallie Blocker. Records of the Charleston wholesale firm of Thomas and Howard showed delivery of 82,600 pounds of sugar and 917 cases of 2-quart jars, each case holding 12 jars. Those went to Blocker. The company also delivered 37,455 pounds of sugar and 252 cases of fruit jars to Ulmer during a 10-month period prior to September 1955. They moved on next to Troy Jones of Sled, who offered a partial record of commitments of prisoners. Defense strongly objected, leaving the court to rule that these kinds of records must be submitted by their proper custodian. Former bootlegger Marion Mitchum corroborated testimony given earlier by Lucius Evans, specifically about still operations and payoffs of $25 per week. Mitchum, who now works as a barber, testified that he and his partner operated a Colleton County liquor still with permission from Sheriff Thompson. When they didn't pay the $50 per week payoff, Thompson cut the still right there on the grounds. After that, Mitchum and Evans were taken by Deputy David Carter to Walter Platt's plantation near Walterboro. They were told they could set up a still on that place for $25 a week instead of $50. Another bootlegger, Kenneth Horn, corroborated earlier testimony given about defendant Walter Platt, the plantation superintendent who accepted payoffs in exchange for allowing stills on his plantation. Friday was a big day with only one witness testifying. The newspapers declared him to be the first witness to testify against Buster, but I take issue with that because Edith Freeman did so on the first day of trial. But anyway, this witness was a 44-year-old retired Marine Corps Master Sergeant and former Colleton County deputy. Another thing he has in common with Edith Freeman is that he, like her, had been spending time in protective custody leading up to this trial. Defense objected heavily to stop the testimony of Riddick Herndon, but of course there was nothing they could do to stop it. Herndon's testimony gives us a lot of insight, and I mean a lot, of how the system operated, which, of course, is why defense didn't want him to speak. As mentioned, Herndon was a Marine. He retired with a pension in 1949 and soon became a fishing and hunting companion of Sheriff Thompson. He was a bachelor who lived with his parents at the county jail where his dad worked. He would sometimes help his father there. In 1952, Sheriff Thompson asked Herndon to assist him on a raid on a still, and he did. For his help, Thompson sold 2 cases of the seized whiskey and gave Herndon $36 for his share. That's $380 in today's money. Herndon's pension was only $145 a month, or $1,660 in today's money. So the money that he earned was about equal to 1 week's salary. Herndon had never had any connection to illegal whiskey before this, and stated that he was very much surprised that such a thing was even going on. From there, he became Thompson's collector. It's interesting to me how he was baptized into this in a way that he himself now had dirty hands. Thompson hired him as a deputy sheriff, but he had no salary for that job. Instead, he collected about $500 a month from the bootleggers. He kept his share, which was 20%, and turned the rest over to Sheriff Thompson. If you'll remember from previous episodes, the U.S. government was holding a campaign to stop the bootlegging trade, and not all state law enforcement was turning a blind eye to it either. Investigations and arrests were being made, and public outcry had to be dealt with as well. So from time to time, these stills would be discovered and arrests would be made. And that brings us to a name we've already heard. He was the second defendant to change his plea to guilty. George McPeak. George McPeak had been arrested. He hadn't taken it seriously. After all, he paid his dues. In fact, he posted his $500 bond and was back out running his still immediately. What happened next is pretty shocking and involves a magistrate judge by the name of P.E. Beach. We'll hear more about him in a future episode. We'll also be introduced to Crosby, the clerk of court, and the topic of checks. Again, we draw some similarities with Alex, where we saw him do his stealing and drug purchases with the very traceable check writing. This clerk of court, Crosby, tells Herndon to tell Magistrate Beach to return the $500 bond to McPeak once he pleaded guilty, which he did on April the 4th, 1955. Magistrate Beach writes a check. The clerk of court endorses it and tells Herndon to deposit it in his account at the Bank of Walterboro. He did so and returned the deposit slip to Mr. Crosby, the clerk of court. Crosby made out a new check for $300, which is the difference between McPeak's $500 bond check that's just been cashed and his $200 fine that he owes the court. Herndon cashes that check, and McPeak, who's there for all of this as well, gives Herndon an additional $200 in cash, bringing the total back up to $500. Herndon is told to keep $100 as his share and to give the rest to Sheriff Thompson. Mind you, this is all happening in the Colleton County Courthouse. Buster walks up just then, and Thompson, who's now holding the remaining $400 in cash after Herndon took his share, peels off two $100 bills and hands them to Buster. A 50-50 split. Thompson tells Buster, "I wish I could get one like that every day." The next day, Thompson tells Herndon that Buster raised quite a fuss about the money exchange happening in front of Herndon. Another important part of Herndon's testimony was that in 1955, during a trip to the South Carolina Wildlife Resources Refuge at Bears Island with Herndon and Buster, Cecil Hamilton asked Buster why nothing was being done to curb the whiskey making in the county. He also mentioned that irregularities were being investigated and that the federal grand jury was about to make indictments against a group of Colleton County citizens and officials. During the trip, they stopped at Sheriff Thompson's home, and Hamilton put the question to Thompson to do something about the bootleggers. Thompson made excuses of his deputies being overworked. Buster drove Hamilton home, then instructed Herndon to go back to Thompson and tell him to get out and make some raids, adding, if only, quote, friendly raids, unquote, and to do it even if Buster and Thompson had to pay the fines. So that's what they did. At one point, they took a photographer along and documented a raid. And it was none other than the Deputy Sheriff Herndon busting up his own still. The photograph ran in the News and Courier, which is now known as the Post and Courier. Not long after, Herndon started to get paranoid when he heard that Thompson, Lucas Hyatt, and Magistrate Berkeley Woods had gone to see Buster. He thought he was about to get double-crossed, so he went to see Buster as well. He told Buster everything he'd seen and knew about. He testified that Buster said, "For God's sake, keep quiet about this. If you need money or get in trouble, come to me. I'll help you." When it was defense's turn to cross, they didn't bother to refute any of his testimony. They resorted to implying he was making a deal to protect his pension. And their reasoning was that if he was such good friends with Buster, why had he gone to other lawyers once he'd been convicted instead of going to Buster? But I think this is a silly question. If the walls are coming down and you know Buster is under the same roof you are, why would you run to him? Defense's next move was to address the McPeak payoff. Interestingly enough, they didn't deny it, but simply said that since it wasn't part of any overall conspiracy to evade federal taxes by illicit whiskey operations, that it should be considered a separate conspiracy, if at all, and argued to have this testimony stricken. Judge Hoffman replied, "Doesn't it strike in substance at one thing? Did not certain people in Colleton County conspire together to defraud the U.S. government in one form or another? In the event that such a thing transpired, anyone who contributes in any manner, knowing that such a conspiracy existed, would then be implicated. If the defendant McPeak had been brought into court for stealing a hog and had not been in the whiskey business, then it would not figure in the conspiracy." Judge Hoffman then scheduled the trial to go on half a day on Saturday. Saturday started with another magistrate, That's the third one now, since Woods and Beach. We now have Herman M. Tuten, a magistrate from Fraser Township, serving his 7th term. He begins by revealing he'd taken money from bootleggers in exchange for allowing them to set up distilleries on his community farm. A lot of his testimony wasn't new information, but a corroboration of facts that had already been revealed in testimony of others, especially Herndon. He also told of a hijacking of a whiskey still by defendant Jimmy Richardson, who had just pleaded guilty the day before. Tuten told that Sheriff Thompson had told him of giving a deputy sheriff's badge to Richardson, who used it to hijack a still. Sheriff Thompson later said that he'd regretted giving him that badge. We begin to see the system unraveling in Saturday's testimony, with Tuten becoming angry when he found out he was being cheated out of his portion of payoffs by Herndon or Thompson, and demanded he start being paid 10 cases, or, as he threatened, he was coming in with a bulldozer to level the place like a polo ground. Cecil Hamilton, the foreman of the grand jury who had put pressure on Buster to make arrests, was next to testify, and he corroborated Herndon's testimony of what had taken place on the day of the trip to the wildlife refuge. George McPeak also testified, corroborating the story of his $500 bond being divided up and paying Herndon, Thompson, and Buster in the Colleton courthouse. He also corroborated other stories told by the other bootleggers. All of the witnesses of the morning were intensely scrutinized by defense counsel on cross, but all of them were described as holding up. Monday brought a long court day. Of note, 3 minor defendants were acquitted by Judge Hoffman. They were George Steve Crosby, Watson D. Crosby, and Charlie Grant. In addition to these acquittals, other defendants had some of the counts removed from their indictments as prosecution closed out their case. Former bootlegger Henry Carl Strickland testified that Sheriff Thompson had confessed to him that the grand jury was on his neck and he needed help. Remember, Buster told him to start doing raids because the grand jury was rounding up indictments. Thompson told Strickland that there would be a friendly raid, that Strickland would have to undergo a preliminary hearing before Magistrate Woods, but that it wouldn't cost him much. Strickland agreed to allow it. On the day of the raid, Thompson came. Only 1 pint of whiskey was found. Strickland and Thompson drank half of it together, then Thompson left with the remaining half pint as the only alcohol seized in the raid. The raid cost Strickland $125 when he pleaded guilty. The list of witnesses went very quickly. Some of them had previously testified, such as Marion Mitchum, Lucius Evans, and ATTD agent Henderson Clary. The long list of witnesses included 2 sled agents, J.L. Dollard and Olin Redd, the chief of the Walterboro Police Department, James Schell, and his assistant chief, P.H. Carter. Theodore Stoney, who was the former assistant district attorney, also took the stand. Defense had been claiming that a lack of prosecution for some of the defendants meant that they were trading prosecution for testimony. Theodore Stoney, however, testified that it was the policy of the district attorney's office and the ATTD to delay prosecution of some persons indicted in conspiracy cases, and that they did so as not to interfere with completion of the overall investigation. Which makes sense. If all these guys start turning up with indictments and prosecution, it's gonna let some of the bigger fish get away. Defense also made the claim that a lot of these witnesses were testifying in exchange for immunity. This was also denied and further backed up when Judge Hoffman said that no such deals would be held up. Woodrow Bloom testified about a friendly raid on his still. He says he was forewarned by D.L. Smith, and the raid was carried out by Sheriff Thompson and his deputy, Herndon. Lee Lyons testified that Defendant Ulmer had approached him, grabbed him by the collar, and threatened that he'd end up toes up for scandalizing his name. Apparently, Ulmer believed that Lee Lyons had told people that Ulmer was in the bootlegging business. The funny part is while accusing Lyons of scandalizing his name for accusing him of being in the liquor business, he threatened him by saying, "Some of us bootleggers will be the ones to turn you toes up," thereby admitting he was a bootlegger. Daniel Adams testified that he made payments of $35 for protection to Deputy David Carter. One of the more interesting bits of information that came out was that the investigators had been recording serial numbers on bills that they would use to track money that was given to informers and passed on to bootleggers to see where the money exchanges would lead. Robert Clifton, who will come up again soon, made the claim in his testimony that shortly after he was cited as a government witness, that the Hampton County Sheriff and some deputies raided his farm and searched his premises. He said they reported finding a jug of whiskey near his property line about 200 yards down the road from his house. He told the court he didn't know who put it there and that he felt this raid was a revenge move. And you have to admit, them not finding a still to destroy, them not finding cases and cases of liquor, only finding one jug near his property line, 200 yards down the road from his house? That doesn't sound like a legitimate raid. But the most riveting testimony of the day is when Agent Clary told of the events the night Doc Freeman was shot. We heard about him being shot when his wife Edith gave testimony on the first day. Now we hear Clary's testimony to describe what happened. He said that he flushed the still shortly after 4 a.m., that he leapt over one man who was sleeping in a pile of charcoal and grabbed another as a third burst through the side of the building of the huge distillery, the side of the building being made up of tar paper. Clary said he chased the man to the house about 3/4 of a mile away and saw him disappear inside through a rear door. He ran in the back door, and Doc Freeman appeared, jamming a pistol into Agent Clary's stomach and telling him to stop real still. Clary told him who he was and started to reach for his badge in his pocket, when Freeman told him, "If you put your hand in your pocket, I'll blow your heart out." Clary said he fled out the back door and ran to his car nearby and got a shotgun. He saw a man appear at the window with what looked like a shotgun, and he fired at him. Soon, the man appeared at another window and he fired again. Shortly after, Freeman walked out onto the front porch, wounded in the stomach and the head with buckshot. He called out, "Don't shoot no more, you've got me." But he wasn't ready to go down, it seems. He suddenly turned and ran back in the house, through the house, to the backyard. Clary said he heard a car start up and came racing around the house. He shot out both of the left tires, and the car stopped, being blocked by one of the other agents' cars. Clary says he ran up, held his gun on him, and tried to search him for a pistol. Freeman grabbed the gun, but Clary shook him loose. Another agent came up, and then Freeman finally surrendered. They arrested the third man, who was still in the house. Once Freeman had been sent off to the Colleton County Hospital, the agents dynamited the still. In addition to this testimony, he told of many trips that had been taken to Colleton County. They began in 1953, carried through 1954, and up through 1955. He also corroborated testimony by other witnesses about the use of tape recording machines, and also whiskey purchases that were made by paid informers with the tracked money. He listed 3 of the paid informants as Oscar Phillips, James Bowman, and Isaac James. He was asked about the first time he met with state's witness Magistrate Tuten. He said that on November 21, 1955, he drove to his hunting club near Jacksonboro, based on a statement that had been made to him by Henry Walker, a bootlegger. Clary testified that he promised Tuten nothing. Clary told Tuten the accusation against him, to which Tuten replied, "I'm going to tell you the truth, if it puts me in the penitentiary or not." He then told Clary to set up his typewriter on the eating porch. Defense continued to pound away at the idea that promises had been made in exchange for testimony. Tuten was one of just a couple of indicted parties who'd turned state witnesses. It's not really so underhanded. The government needed witnesses, and a person cannot be both a witness and a defendant. It was a very limited number, and it served a very important purpose that's done throughout history, even in our time. It wasn't some underhanded move by prosecution. It was really that simple. And with this long day of many witnesses, prosecution rested. Defense was slated to begin their witness testimony the next morning at 11. The newspaper stated differing numbers on how many witnesses the prosecution had heard from, the highest number being 42. So obviously somewhere around half of their witnesses went unreported on, because I've listed every single one I could find in every local newspaper. 2 witnesses whose testimony wasn't reported on were Mr. and Mrs. Hallie Avant, who were subpoenaed all the way from Eureka, California. Defense originally stated that they expected to get through their entire testimony today, prompting all the headlines to speculate that the case might be headed to the jury. They started their testimony swiftly moving through 16 witnesses in one day. Among them were Magistrate Berkeley Woods and former Deputy Sheriff Walter Hyatt, both denying all allegations against them. Woods specifically denied all allegations that he had implicated Buster by telling bootleggers that he would speak to Buster when he saw him at an upcoming fish fry about their concerns. Apparently, this was something that several bootleggers had said happened. Mrs. Ulmer, who had been removed as a defendant, was now recycled as a witness for the defense. Her husband is still a defendant. Hyatt denied a $50 payment to the undercover agent O.B. Jarvis, to which Assistant D.A. Howe responded that he could clear that up right now with the recording of the conversation. Judge Hoffman hinted at disciplinary action for the crime of perjury. Ben Magwood, who called himself a water finder, also known as a diviner, testified that he never had any hand in any part of the production of illegal whiskey or even the well digging. He explained that he is a well-known water finder in the area and only served to locate spots where water might be found. He told the court how he does it, indicating that if he took a dogwood branch, held it a certain way as he walked on the ground, that if there were water running underneath him, the branch would bow down in a certain way. Sheriff J. E. Smith of Allendale testified to only one question, whether or not he summoned Buster to the scene of the shooting of Doc Freeman. An important part of Buster's defense was trying to explain certain situations where he either appeared or paid someone as being related to his actual work as solicitor. So defense explained Buster's presence at the shooting and the busting up of Doc Freeman's still as being there because the sheriff had called him. Not much else is printed about the rest of the testimony given by the 16 witnesses, but motions were heard, and among them a motion to dismiss conspiracy and other counts against Sheriff Thompson were overruled, as was a motion to dismiss the conspiracy charge against Buster. Conspiracy charges were also dropped against Herbert Bodison. Bradley Frazier changed his plea to guilty, making him the 5th defendant to do so. Character witness C.G. Paget of Walterboro Bank and C.A. Witzel, a Walterboro merchant, were there on behalf of plantation owner Walter Platt. Walter Platt was mentioned earlier as allowing stills to be put up on his plantation in exchange for money. He and his witnesses strongly denied this, though multiple bootleggers had already testified to doing so. G.B. Britt, a forestry ranger, also served as a character witness for Berkeley Woods, saying he never saw a still on his property. But when Britt was asked what he does when he comes across stills in the forest, his answer was that he leaves them alone. Basically, it was a very fast-moving day full of denials. State Circuit Court Judge J. Henry Johnson of Allendale took the stand as a character witness for Buster. He testified that the cases that came through court that had allegedly received light sentences seemed to be in harmony with the sentences generally given during that term. It could be that Buster simply gave all bootleggers a break, or it could be that they happily took payoff money and never actually provided them with much protection at all. The judge also testified that he didn't remember Buster ever giving him any recommendations on any specific cases. He then drew laughter by saying that some of these cases might have been light because the defendants were represented by James P. Harrelson and I.A. Smoke. Continuing on, they are the best beggars in South Carolina and really know how to cry on a judge's shoulder. The court found it particularly funny because both attorneys were present in court as defense lawyers. The day came to an end with a long discussion about Sheriff Thompson's health. Claude Sapp, Thompson's counsel, was trying to interject Thompson's health into the picture as possible explanations for some of Thompson's behavior. The district attorney was not having it. The jury was dismissed, and Sapp told the court that he wanted Thompson's physician to testify. And Sapp told the court that he wanted to ask Thompson's physician whether Thompson would be endangering his life if he took the stand to testify. Specifically, he wanted him to testify about having had strokes and his mental and emotional state. The judge asked, is he pleading insanity? If so, he can't be tried for a crime. The judge asked Dr. McDaniel whether or not Sheriff Thompson could tell right from wrong during the time he treated him, to which the doctor replied, I don't think I can answer that question. After long discussions, Judge Hoffman ruled that Dr. McDaniel could testify but limited it to actual dates during which Thompson was hospitalized or confined to his home, and Dr. McDaniel shared some of that information, such as Thompson having a stroke December 28, 1953, after which he spent nearly a month in the hospital. Dr. McDaniel said that it was possible that Thompson could have a cerebral thrombosis on the stand. Judge Hoffman asked, "Doctor, doesn't that danger exist for all of us to some extent?" To which the doctor had to answer yes. Thompson's defense was attempting to line up his participation in the alleged conspiracy was during the periods when he wasn't well. And then we get to Buster's testimony. When I read about Buster testifying, I can't help but think about Alex. Alex seemed to worship his grandpa Buster. So I wonder, is this trial what Alex had in mind when he took the stand? Was he trying to channel Buster, who had beaten his review before the board just years before? He'd also beat a second investigation that we'll touch on today. And then we come to this trial. He was able to get out of all consequences every time. And I think Alex might have imagined that this is how it was going to go for him as well. I wonder if he was stuck in the past where these things were able to happen. But Buster's era was a time gone by. As we've covered in the last several episodes about Buster, he was the man in town that controlled which cases went to court. He was the man who made himself known to potential jurors to win their support when needed. He was related to important men. He was involved in as many organizations, sports, clubs, you name it, around town as possible. His wife was involved in all the things the ladies did in that time as well. Flower clubs, bridge clubs, baby showers, wedding showers. Buster's son was following in his footsteps. He was in the paper constantly for his abilities in sports. All signs pointed to him following in his father's footsteps. Alex had nothing but a tired name behind him. He had none of those things that Buster had. And now, on this day when Buster took the stand, all his hard work in the community was about to pay off. After all the lead up to Buster's testimony and all the reporting on everyone else's testimony, I found it terribly disappointing how little substance any of Buster's testimony that was reported on actually contained. The headlines copied each other with titles remarking on a battle of wits or tempers. Yet after scrolling through countless newspapers, I don't find much on what these wits were. I find denials. Many denials. But none of it is witty. I didn't see any aha moments. It's the exact denials that everyone was expecting. And it's pretty easy because the burden of proof rests entirely on prosecution. Naturally, Buster offered little explanation on his lack of guilt, simply denying situations or explaining things such as why he was at certain events or why certain monies were spent by saying they were simply part of his duty as solicitor. We see him asked about large payments made to Thompson, one almost $2,000, another almost $1,000, which was definitely a lot of money in that time. But Buster said it was payments for Thompson's investigations. He also claimed it was repayment of money spent by Thompson to take care of the families of men injured in accidents. Buster claimed that it was the custom for lawyers to get someone to take care of a family needing help while a claims case was being tried. We know little of the content that caused tempers to flare, but we read about tempers flaring so badly between District Attorney Belzer and Buster that Judge Hoffman had to stop the heated interchange, saying, "Now you two lawyers quit arguing. Next week, if you like, I'll arrange for boxing gloves, and you can have it out. Right now, let's get on with this case." Some of what we learned was about Buster's associations being called into question. Earlier, the name Robert Clifton came up, and I said we'd get to more of that, and we're doing that now. Robert Clifton was a bootlegger. He was described as completely untrustworthy by defense's own witnesses. Buster's secretary stated that she'd only ever known Clifton to do bootlegging. She also said that Clifton's daughter had been Buster's secretary before she was. And this begs the question, why was Solicitor Buster such good friends and so connected with such a man? They were well-known hunting and fishing buddies. Everyone knew that Clifton was a bootlegger. Yet when District Attorney Belzer asked Buster how he knew Clifton, Buster says he knew him as a farmer. When Howe asked if Buster had investigated Clifton as a bootlegger, he finally had to admit that his firm had defended him on federal charges of bootlegging, but then added, and this rubs me the wrong way, "We've been on deer hunts and dove shoots, but we were never close." And this is the part that bothered me. We're not in the same social class at all. I've never visited him at his home, nor he in mine. To drive the point home further, he adds, I recall planning a suit against him once for wife-beating. Howe highlighted that Buster had represented Clifton in court for his bootlegging charges and wondered about how his solicitor, who by definition is supposed to be convicting such a man for such charges. Buster only replied that it wasn't against the law for him to do that. And Buster, of course, denied everything, even the fact that Clifton had testified that Buster had once advised him to move his whiskey still to Colleton County, where he could operate freely. During this part of the testimony, Buster said that he'd represented him in court and sued him in court, and he mentions that during federal court last year, that Buster had to pull off a case that he was handling for Clifton. At this point, the DA jumps in on this, perhaps hoping that Buster's mention of this particular case might have opened up an opportunity to speak on why Buster had to postpone that case when he asked, and you also postponed that case once because of your income tax matters. Edens objected, and the judge bore down on Belzer, stating, Mr. Belzer, you're going to get more than just a mere reprimand. You know that that's inadmissible as evidence. I'll fine you for contempt of court if you continue. I'm not going to let a man be convicted in this court because of innuendo. What he's referring to here is a situation that Buster went through when he was again under investigation. I mentioned it earlier in this episode, and this is what I was talking about. It turns out Buster was investigated for not paying his income taxes. In the end, some of the charges were past the statute of limitations, and the judge decided to believe Buster that it was a simple case of him having terrible bookkeeping. So yet again, Buster faced serious charges. Charges that the average person would never have been able to find a way around. You have to pay taxes, and poor records, poor bookkeeping cannot be an excuse for not paying your taxes. And it's even more shocking that it was the circuit solicitor. To make it even more ridiculous, Clyde Eltzroth was his partner. Clyde was the appointed tax collector from 1946 to 1953. During this time, Clyde studied law in Buster's own office from the late 1940s, passing the bar and becoming Buster's first law partner in 1952. He remained his law partner until 1975 when he became a judge, and even then still kept office in Buster's law firm. Of all people, Buster had no excuse for not paying his taxes during this time. He had the tax collector in his actual office most evenings. How was he not held responsible for not paying his taxes? How did he never, in all of those years, say, hey Clyde, how about since you're getting a free law education here, you take a look at my taxes? I mean, it's mind-boggling to me. And how did the court let him slide? But putting this all together, things we've uncovered in the series already, there were a lot of things going on in Buster's life. And personally, I feel that much like the storm Creighton Waters spoke of that was coming to Alex, these issues coming to Buster were also a storm. Maybe not as big by any means as what was going on with Alex. But when you put it all together, it could definitely point to motive for him being involved in a quick, easy, money-making scheme like bootlegging. Reviewing some of the things that we've uncovered, he had settled privately with Ruth Cram. She was suing him for quite a large amount, so I'm assuming the settlement was large as well. He had multiple properties we discovered that he owed high back taxes on. These properties were posted in the paper because he was so far behind that they were about to be taken and auctioned off. He lost his business. It was taken and auctioned off. He had to pay back these income taxes now and the fines that went with them. He was a solicitor, and a solicitor's salary is by no means large. He did have some large cases involving the railroads, but some of those were being tied up in appeals and Supreme Court hearings, so that held up payment for years in several of those cases. At the same time, as we've mentioned many times, he was living large, keeping up with others around him, hosting lavish parties with important people, driving his Cadillac, smoking his Cuban cigars, so many things. Now these income taxes. The article shows that he owed $16,000 in taxes and $7,000 in fees, or a total of $23,000. That's $266,187.79 today. The additional $14,000 from 1945 was past the statute of limitations, or the number would have been $427,866.91 today. But yes, Buster had a storm bearing down on him. But going back to the trial, Judge Hoffman did not like this being brought up. It had not been cleared to be discussed during this separate trial. He threatened D.A. Belzer not to bring it up again, or he would hit him with contempt of court, in his words, if he pulled any more shenanigans. They moved on. Buster's friendship with Sheriff Thompson was mentioned. Buster and Sheriff Thompson were political friends in addition to being hunting and fishing friends. Another little drop of information came from D.A. Belzer when he asked Buster about kiting checks. It's reported here he said, "Did you tell Sam Carlton, who's a federal income tax investigator, that you and Sheriff Thompson had been kiting checks on each other's accounts, and that you stopped it only after you read in the newspaper that it was illegal?" So kiting checks. It's not so easily done today because, one, we do most things electronically now. We tap our debit cards at the checkout, and it instantaneously withdraws the money. We have auto pay set up on our bank accounts to pay our bills, and those are automatically deducted. Banks have also long had protective measures put in place where if you deposit a large check from another financial institution, those funds, or at least a portion of those funds, are held until the money is physically received by the bank from the other institution. But back in Buster's day, they could play Beat the Bank. Beat the Bank is where, say, you know your paycheck would be deposited on Friday. You want to buy something on Wednesday. You know on Wednesday that you don't have the money in the bank, but you also know that it's going to take 2 to 3 days for a check to physically clear your bank. So you could write that check on Wednesday, knowing that your paycheck would be there on time on Friday by the time that check clears, so the check won't bounce. Now, some people took that further and devised ways to basically keep money floating on air, or kiting. Maybe it wasn't that you're simply waiting a few days for your paycheck or some other money to come in. Maybe you're waiting much longer, or you're just simply living dangerously with money that you don't have. You could have 2 accounts at different institutions and write checks back and forth to yourself before they have a chance to clear. But as long as you keep those checks floating, the money is never actually taken from either account. Now, after some time, that would be suspicious if you're just cashing checks to yourself over and over again. So apparently, Buster and Thompson were writing checks back and forth to each other at some point, which is called circular kiting. Now, this can go on endlessly till you're caught or you default on a check, or ultimately come up with the money to pay it back. Of course, Buster's attorneys objected profusely at the mention of this, but even though the judge overruled those objections, Belzer did not expand on it. I really wish he would have, because this is another piece of Buster that we saw reflected in Alex. Alex had Russell Lafitte helping him, and Buster had Moses Lafitte, both of them always living beyond their means. And this kiting is another example of how desperate for money Buster was during these times. But it also shows how very close these 2 men actually were, that they were involved together in this sort of financial trickery. Usually it's not just a casual acquaintance that you're going to trust to be involved in this kind of bank scheme. I mean, imagine going up to someone that you barely know from work and saying, "Hey, let's write these checks back and forth to each other." It's going to be someone you trust and someone that you know well enough to know that they're going to be okay with this kind of scheme. And it shines a light on exactly what Sheriff Thompson was to Buster. Thompson was very useful in so many ways. Buster had been very careful to put the mediation largely in Sheriff Thompson's hands. It also helped Buster that Sheriff Thompson was not a discreet or cautious man. He was greedily blundering his way from still to still with his eager hand out for money and whiskey. He was the perfect scapegoat to take all the blame for Buster. Thompson's face was the face all the bootleggers knew. Buster was mentioned and he would make an occasional appearance, but he was very careful to let it be Thompson that was out there being known and seen by everyone. It made for very little actual evidence that could be pointed to Buster. As mentioned, When Buster paid Sheriff Thompson for something, he could explain it away as something official. If he was called to a scene, he could say it was in his official capacity, while Thompson was left holding the bag. Another difficult topic for defense to broach was Edith Freeman, who had given very riveting testimony and who had that little blue notebook. Of course, it was even easier back then to dismiss a woman, and that's what he did. He dismissed her as a woman angry that her husband was shot, angry with him for not taking action against the agent who shot him, and angry about the stolen money. He added a lot of things in his testimony that he said without any proof at all. Again, the burden of proof was completely on prosecution, so he didn't have to prove anything. But making these kinds of comments was a big way of deflecting. He claimed to have gotten in contact with the federal officials in Columbia and was told that the Freemans were about the biggest bootleggers ever to come out of Georgia. It hardly sounds like something that would come out of a federal agent's mouth, especially to Buster. But then again, he's defense. He doesn't have to prove anything. But in spite of all the attempts from the defense team, not one of the witnesses, in all of the ones that testified, faltered in their testimony. Their eyewitness accounts corroborated each other in a way that I feel is not likely to have happened if the stories had simply been made up. When you're trying to tell a falsehood, especially so many different people, there's bound to be some crack-ups along the way, and there really wasn't amongst all of these eyewitnesses. And for the rest of the testimony, defense counsel for all of the other defendants besides Buster were heard. Much like for Buster, there wasn't really much any of them could do besides attempt to cast doubt on all of the witnesses. Next episode, we're going to close this story up when we consider closing arguments, the verdicts, and the aftermath of those verdicts. In Murdaugh Mafia Rise and Fall, Episode 10. Until then, this is Cassidy O'Connell saying stay well and stay tuned. I also want to remind you that Juror Amy, that some of you have seen in interviews after the trial, has written a book with co-author Shanna Hirsch. The book is due for release sometime in November, but you can pre-order now. I have the link to do so in a community post here on my channel. I, for one, am very excited to hear her story.